Hi there. It's been a little while since we discussed our friend Ms. Jackie Robinson related to the AVI versus MHVB case in the Alberta Court of Queen's Bench. She had until, I believe it was the end of September 2020 to submit documents to the court to justify her representation of someone in the family law matter. Well, Justice Gracer has come down with another decision, and I'm going to let you know what the decision was and provide my comments on it. So the case is AVI versus MHVB 2020 Alberta Court of Queen's Bench 790, which is the legal citation. It's a decision by Justice Gracer, acting as a sequel to his previous decision, where the court encountered a tumultuous child custody battle in which an unauthorized third party sought to interject on behalf of the mother in the case. What brought this case some degree of notoriety over any other family law case is that the unauthorized third party representative subscribes to a movement of pseudo-law based on a presumption that the current executive, judicial, and legislative branches of Canada were illegitimate, and as such engaging in treasonous acts, all because a committee of barons had petitioned the Queen in 2001 invoking Article 61 of the Magna Carta. Before engaging in the details of Justice Gracer's decision, to truly appreciate and understand the sheer magnificence of the Justice's decision, recognition must be afforded to the initial paragraphs of the decision where Justice Gracer personifies the followers of this practical lawful dissent movement as, quote, typhoid Marys, unquote, who spread a, quote, disease of ideas, unquote. This is an important label, as in this description, the Justice captures the nature of what this movement is, what they seek to do, and what they seek to do is pervert the rule of law. Perhaps the Justice could have gone further and compared this movement to a cancer, for like a cancer does to cells, these gurus will seek to poison the original entity, and in this case, the legacy that is the Magna Carta, and mutate it until all that's left is an unrecognizable shell that will create further harm if it's allowed to spread. Just like a cancer, the Justice notes that all of these OPCA litigants, a term coined by Associate Chief Justice Rook in the Means versus Means decision, another brilliant decision on these groups. These litigants could be ignored. It is vital that the public be protected from them, and in this case, the court's going to ensure it happens. If the unauthorized third party, in this case, Jackie Robinson, was a disease, the court would be the vaccine. Justice Gracer labels this movement as the, quote, Magna Carta lawful rebellion, unquote, and further goes on to explain that this movement subscribes to a notion that if one swears an oath to a baron, in this case, Lord Craigmile of Inverness-shire, they are now, quote, outside the UK and Commonwealth state, court, and police authority, and you are now sworn to the barons who petitioned against the EU in 2001, unquote. The first chink in the armor of this movement comes from the fact, as the Justice points out, that Lord Craigmile actually has no idea why these individuals are sending him oaths, and has gone on the record to state he wasn't entirely sure what happened when Article 61 was invoked in 2001. Outside of the court case, the movement has used several documents to validate their claim, including an article written in the Daily Telegraph, which at first seems to support the movement's principles. However, even in that article, the author notes that had the Queen not responded to the petition, the barons would begin seizing her castle's properties and assets. Even that author did not support the notion that a government is toppled or invalidated due to this clause. Furthermore, the Queen did not provide the redress the barons sought, and yet she still has all her assets. So, by the logic of this group, are the barons now traitors as well? The second fallacy that is born from the movement's beliefs is exactly what was the function of Article 61. It should be noted on the group's very own Facebook page, a link to a video in the Library of Congress is posted where Chief Justice Roberts of the United States Supreme Court discusses the legacy of the Magna Carta. In particular, he notes that the legacy of Clause 61 is that no executive or king is above the law. A prime example of this is the 25th Amendment of the United States, which allows for the removal of a sitting president if he is no longer fit to govern. Other countries have similar provisions to ensure that executives of the state follow the law as the law comes first. Now, in the video by this group, it's explained that Article 61 would allow for the barons to take control of the country in the event a king was in breach of the charter or after having been notified did not redress the breach. The MCLR movement would believe that this invalidates the government or the monarchy. However, that is not the function of the clause, nor is that what was stated. What actually would occur is the barons would assume the day-to-day running of the country according to the law. Article 61 addresses specific breaches. It does not purport to vitiate any past actions of a monarch or executive so long as they were in accordance with the law. Furthermore, the original Magna Carta was not some ethereal document that descended from a divine being or is unchangeable by man. The reason that Magna Carta's legacy is recognized at all is that because it is the foundation of many states that exist today, and the ideals are enshrined in various constitutional documents. Simply put, the Magna Carta was the beginning of the evolution of modern law, not the end of it. Finally, and possibly the most overlooked problem of the movement, is the Magna Carta only gave the barons the right to seek redress and take action. Nowhere in the document were rights and responsibilities afforded to ordinary citizens to seek redress. Ms. Robinson is no baroness, and therefore the Magna Carta affords her no power. Returning to the Alberta case, Justice Gracer goes on to speak of the developments in the case, namely a warrant being issued for the mother's arrest, and the issuing of further documents from Ms. Robinson to both Justice Gracer and Associate Chief Justice Rook, as well as issuing documents to the clerks of the court. The Justice notes that Ms. Robinson provided no explanation as to why she should be allowed to continue to represent the mother. She just continued to attempt to coerce and intimidate the court with her ridiculous documents seeking relief. In coming to a decision on how to proceed forward, the Justice provided a more than fair evaluation of why Ms. Robinson should be prohibited from acting as a representative of anyone. Furthermore, the Justice did not inhibit any rights Ms. Robinson would have with regards to her abilities to appear in court on her own behalf. His decision was proportionate and fair and kept in the spirit of the law regarding vexatious litigants to target the specific vexatious behavior and protect the courts from being subjected to it. As Justice noted, it may appear he utilized a sledgehammer to crush an ant. But as was stated earlier, it's more like utilizing a vaccine to prevent the spread of disease. My response to the Justice's decision would be, no, my lord, this is not using a sledgehammer. What Ms. Robinson and her movement are doing is not only an attack on the courts, it is an attack on the society that countless people have devoted their lives to, some of whom were assassinated while effecting change. A society born off the blood of countless men and women who died in the name of freedom. She seeks to destroy a system that has evolved over centuries and return us to a time of anarchy and savagery. Also, she and her followers don't have to pay rent or their parking tickets. On this battlefield, my lord, our country look to you to defend what we hold dear against an enemy who sought to tear society apart, just like the Allies had done when the Nazis threatened to change the world. Your decision was not a sledgehammer crushing an ant. This was a vaccine to a virus. This was bringing a gun to a gunfight. If anything, perhaps the Justice needed an even bigger hammer, but only time will tell. Take care.